G'day, Professor Joseph Drew here. I've been asked to talk about the options for the future for communities that were amalgamated recently in the 2016 New South Wales Amalgamation Program. So, according to my thinking and according to the scholarly literature, there's really only four options open. Option number one, we do nothing. We don't do any special rate variations, we don't put up fees, we don't change any of our spending programs, get rid of discretionary spending or cease programs, we don't reduce staff numbers, we do nothing. And that is an option that some councils are clearly taking. The outcome, the ultimate outcome must be disaster. It will be a failure of financial sustainability, and indeed a financial failure, and the council will be put ultimately into financial administration. So that is an option. It's not a very good one. Basically, if you're going to increase your costs by just over 11% on average, your unit costs, and you're not going to increase your revenue, and you're not going to cut back elsewhere, it's going to end badly. Just like if you did the same thing in your private budget. If you suddenly started spending 11% more, but you didn't earn any more, and you didn't cut back anywhere else, ultimately you would go broke. So option number two is we make the victims pay. And this is what some councils have done. They've been forced to do it. They didn't want to do it. So, Cootamundra Gundagai had to put up local government rates by 53.5%. We also had rates go up at Canterbury Bankstown by 36.34%, Georges River by 32.6%. These are huge tax increases, and essentially what we're asking is for the victim to pick up the tab for a really bad policy decision made prior to May 2016. Now, this is just plain unfair, and it's really hard to defend on moral grounds. The picture I've got on the slide there is of someone rear-ending another car, and I often refer to the situation just like that. Imagine I was driving my car. I've got a whole seat full of backseat drivers, maybe someone from Ernst & Young, someone from KPMG, someone from the IPART, someone from the so-called Independent Expert Panel on Local Government Reform. And for some reason or another, I decide to close my eyes and just go entirely on what these people tell me in the back seat. And they tell me to swerve. And I run straight up the back of your car. Now, what would you expect me to do? You'd expect me to do the right thing. The thing that's required of law, but also the moral thing. You'd expect me to get out of my car, apologise profusely, accept the blame and the responsibility to fix things that I caused. You would expect me to pay to fix your car, to put it in the same position as what it would have been in had I not made the disastrous decision to listen to my backseat drivers. That seems to be the reasonable thing. But at the moment, the parties that were engaged in Fit for the Future, parties that decided for these amalgamations, and it also refers equally to the ones in Queensland, they're not accepting responsibility for their poor decision making. And consequently, councils are faced with the decision whether to go broke or whether to put huge tax increases on to stay financially sustainable and stay financially viable. And many of them, to their credit, have taken great courage, gone to their communities and said, look, we don't want to do this. This is because of the amalgamation. Cootamundra Gundagai did that before the last local government election. We have no choice. This is what we have to do, or you simply won't have a council. You'll be in a decade of financial administration like Central Darlingshire with no voice and no say in your community at all. So option one was we do nothing, we get a disaster. Option number two is we make the victims pay, make the ratepayers pay for someone else's bad decision making, someone else's mistake. Option number three is what we would normally do morally and what would be enforced in a court of law. The person who forced the bad decision, the person who compelled councils to amalgamate, many of these councils against their will, Now, for instance, Cootamundra had got expert advice that said it would end in disaster, exactly how it did end, yet they were forced against their will to amalgamate. Now, what would be required in a court of law in the case, the example of that car crash? It would be required that the party who was driving would have to pay to put that council in the position they were in prior to the disastrous decision. So what does this mean? I've got two double-blind peer-reviewed papers now in the best journals in the world, which clearly show that the average outcome because of the amalgamation was an 11% increase to unit costs. Well, the obvious remedy is an untied grant provided by the party that forced the amalgamations, the state government of New South Wales, of 11% to the councils that were forcefully amalgamated against their will. That would compensate them and put them in the same position as if that disastrous decision, as if that swerve into the back of their car had never taken place. That is a solution. It's not a solution the New South Wales government's going to like, obviously. But why should the victim pay? Why should the pensioners, the mums and dads in Cootamundra and all other communities like that have to pay the 53% increase to their tax because of a decision they never made, a decision they fought tooth and nail against? Why should that happen? How do we defend this morally? And as it turns out, the New South Wales government was given incredibly and exceptionally bad advice. And they in turn have a legal remedy, and that is to seek damages from the parties who gave them really bad advice, whether that was the independent expert panel or the KPMG or Ernst & Young or IPA or TCOP or whomever they want to blame. They can go after them for the money. But, as I said, why should the innocent party have to pay? It's only reasonable, it's only lawful, it's only morally defensible for the parties who drove the car to pay to put the community back the way it was. And it's just not 11% 1 year, it's an 11% ongoing untied grant that would need to be paid. And constant econometric studies would be done to make sure that it was at the adequate level, and plus we'd have to pay for the last 4 years worth of disasters as well to put these communities back in the position that they should have been in. The other option, and I do like this picture, and I'm not supporting any de-amalgamation campaign, I just like the picture, is to de-amalgamate. Now we know it works. We are the de-amalgamation kings of the world in Australia because we are the kings of really badly thought out and incompetently handled amalgamations. It's quite embarrassing when I go overseas at how bad we are at doing amalgamations. Amalgamations can be done well. And if you get true experts that have the scholarly knowledge and you get the consent of the community and you bring the community with you, they can be done quite well. But we choose to always get non-experts, the equivalent of a GP to do brain surgery, involved. We choose to ignore the community. We choose not to give the community a binding say. We choose to pay lip service to community engagement, which is even worse, those silly little meetings where everyone gets to stand up and say their piece in 3 minutes or less as if it achieves anything, and then we just ignore them anyway. That's what we choose, and hence we choose to be in the diabolical situation that we are in now in New South Wales and some of the councils in Queensland, where we are heading off the cliff of a fiscal abyss. It's been made worse and compounded by the ridiculous rate cap that's been set by next year, but a lot of these communities just won't survive. Now, it's also been made worse by the fact that a lot of communities put off the special rate variation because of the delay to the local government elections, and then those elections were put off once again, so they've missed this year entirely. They'll be looking at putting their hand up next November. My question is, will next November be too late? Now, in terms of money, it's actually going to be cheaper in most cases. Not all cases can be de-amalgamated, do not get me wrong. Some were never viable to start off with. But in the cases where it is viable to de-amalgamate the council, it will be cheaper to de-amalgamate them than to pay what is morally required, which is at the moment 11% extra as an untied grant year after year after year. It's a bit cheaper just to do a one-off de-amalgamation and pay for that. So they are the options. We could also help councils one-on-one, giving the community and the councillors and the executive the information they need and the truly bona fide expert help that they need to get through this, to navigate the situation. I've helped a community that was mid-flight off that fiscal abyss. They were about to crash and burn. I know it's possible. I didn't enjoy doing it. It was a terrible thing to do, because the truth of the matter is there's only one way to fix these disasters, and that is to increase the revenue and cut back expending, and indeed to do both of those. And that causes a lot of pain, unnecessary pain. I just wish back in 2015, when I was making public appeals for people to come and listen to me, the government decision makers, to spend some time with me, that they had taken me up on that and got some true expertise, and we could have avoided all this pain. Thank you very much for your time. Goodbye.